basically UPSC wants, and also evolution. So what it wants you to analyze is how did Indian constitution come into effect. Again, the list is endless. You can go into elderly, you can go into sexually exploited and this and that and everything, but I think this list should be enough for you to. We require anti-terror laws and fundamental rights have no importance. That our information, private life information may be misused or may be leaked by someone else who has access to it. 95% of their funds, they are dependent on either the transfers from the center or the state.
The UPSC exam doesn't defeat you with difficulty. It defeats you with confusion, lack of clarity, lack of direction, and preparation that feels scattered. At Vision IAS Delhi, we rebuild your UPSC journey with structure, strategy, and support that doesn't waver. Get complete coverage of GS, CSAT, and essays step by step. PT 365 and Mains 365, so current affairs stop feeling like chaos. Personal mentorship, not just advice, but actual strategy guidance. Test feedback loops, because growth begins where guesswork ends. Toppers didn't just prepare, they built the right foundation. Now it's your turn. This isn't just a course, it's where clarity, consistency, and confidence begin.
You have written the prelims this year? Okay. And how many of you expect that you'll be able to qualify the cutoff? Okay, quite a substantial number of you. Right, so the objective of this session is twofold. The one objective, of course, is to understand what kind of questions that UPSC has been asking in the past from specific topics of polity and governance, and also to understand what can be the themes on which UPSC may ask questions in the coming years. Second objective is that we will spend some time on certain questions, not on all questions because it's not possible. We are covering 3 years previous year questions for the 2022, 2023, 2024. That almost amounts to, if I'm not wrong, around 40 questions. So it will not be possible to discuss all those 40 questions, but maybe 10, 15 questions or maybe 20 questions we will try to discuss what possibly the approach could have been to write the answers to those questions. I have done this in the past earlier as well for these specific years. When the exam happens, after that we conduct an analysis session, but some of you may not have seen it earlier. So the idea will be to tell you what exactly UPSC expects in an answer from the candidate in those questions. And as I said, the first objective would be to understand what possibly can be the themes, how do we prepare those particular topics going ahead in future. So so that's the objective of this particular session. Of course, I will also take inputs from you from time to time. If you have any inputs to give on what possibly could be included in the answers, and what do you think as far as the challenges are when it comes to preparation for these topics. Because I feel that in mains examination, the biggest challenge that most candidates encounter is where to set the boundary for how much we should study. And secondly, what are the sources that we should be referring for those particular topics. So we'll start with the session now. Right, so as far as polity and governance topics are concerned, this is what the weightage of polity and governance out of 250 marks in the last 5 to 6 years has been. So I have included the pattern for last 6 years, but you will see that consistently the weightage of polity and governance has been around 150, 160 marks out of 250. But that is not where the importance of polity or governance stops as a subject, because this is particularly useful in ethics as well. You would find that when you're writing answers to various case studies as well as theoretical questions, understanding of constitution, understanding of the governance issues helps you in answering those questions in a better manner. Secondly, even in the essay, you would see that out of the 8 topics which are given by UPSC every year, there would be at least a couple of topics in which you can definitely bring in constitution and polity issues directly in your essay writing. Anyway, so let's move further. These are the topics which I'll be going by as per the syllabus of the mains examination to understand the trend analysis and as well as to understand what are the kind of questions that UPSC has asked in the past. As far as this particular topic is concerned, we have seen year after year that there has been at least one question which has been asked related to this particular topic. This, if you look at the topic, it says Indian Constitution historical underpinnings. Okay, so what basically UPSC wants, and also evolution. So what it wants you to analyze is how did Indian Constitution come into effect? In mains examination, their focus would be more on what were the influences that led to the writing down of the Indian Constitution. So if I were to talk about this particular aspect of historical underpinnings and evolution, these are the following things that you need to prepare. Firstly, role of freedom struggle and colonial history in provisions of the Constitution. So how has the freedom struggle led to the evolution of certain principles or certain provisions of the Indian Constitution? I'll give you a very simple example. It was the experience of caste-based discrimination that existed in India that led the Indian Constitution makers to include the provisions related to abolition of untouchability under the Indian Constitution. It was the weak position of the women, underrepresentation of women in politics, in public life, that led the Constitution makers to include provisions such as Article 15 Clause 3 to allow the state to make special provisions for the advancement of women and children under the Constitution. You may also talk about the provisions of Schedule 5 and Schedule 6, how they were influenced by the colonial experience. Why? Because we felt during the colonial times and prior to that as well, the tribals, there was a significant interference which was made into their lives, which led to tribal rebellions and uprisings as well, which we have read in our history classes. And you would be talking about how the provisions of Schedule 5 and Schedule 6 were aimed at addressing that historic injustice that was caused to the tribals of India. So what I want you to understand here is that you just make a short list of provisions in the Indian Constitution and how they were influenced into the Indian Constitution because of the past experiences that we had. If you can just make that short list, if any question comes related to the evolution of Indian Constitution in context of the history of the Indian Constitution, you will be able to easily answer it. Right? Then similarly, another thing which you can possibly give some weightage to, even though UPSC has not touched upon that particular topic, either in prelims as much or in mains, is associated with this particular issue would be of the role of the colonial acts in evolution of Constitution of India. In this specifically focus on the 1861, 1891, 1909, 1919 Act. I would suggest that you look at the influence of Government of India Act of 1935 on the Constitution of India separately. This you can prepare very briefly. How did the Indian Constitution evolve out of these colonial acts? 1861, 1891, 1909, 1919. What were some of the brief provisions of these particular acts that influenced the formation of the Indian Constitution? This you need to do in bit more detail. Here, UPSC expects you to know what were the salient provisions of the Government of India Act of 1935 and what are the provisions in the Indian Constitution that have been borrowed, not all, but broad provisions of Indian Constitution that have been borrowed from Government of India Act of 1935. This is very important because almost 85% of India's Constitution has been refurbished, has been adopted from the Government of India Act of 1935. So it's important that you know some of the salient provisions, some of the important provisions of this particular act. And you also know which particular provisions have actually been borrowed into the Constitution of India. So this is another important aspect which I would suggest that you people should prepare. Now, in the historical underpinnings and the evolution of the Indian Constitution, another important aspect that you should prepare is the role of Constituent Assembly in drafting the Constitution of India. What was the role that was played by the Constituent Assembly in drafting the Constitution of India? Here, specifically, prepare some points over the debates that took place in the Constituent Assembly, how they were very enriching debates. Possibly make certain pointers over the kind of diversity that existed in the Constituent Assembly of India that led the Indian Constitution to become reflective of the Indian society. In that, you may specifically prepare the topic related to role of women. There were limited number of women in the Constituent Assembly of India, but they played a significant role. So you should know some names. Some names of members of the Constituent Assembly of India. Some prominent names. Don't just stop at Dr. B.R. Ambedkar all the time. There were many other members as well. So if you could just prepare very briefly, what were the diversity of viewpoints that were brought in by different members of the Constituent Assembly of India in the drafting or the framing of the Indian Constitution? In this, as I said, role of women also becomes very important. So just prepare 2-3 names and maybe some important contribution which they made towards the provisions of the Indian Constitution and the debates that took place in the Constituent Assembly of India. Even if you prepare just maybe 3-4 names here and there, and if you just prepare some one-liner contribution also that was made by them, that would be enough. It will prepare you for any unexpected question. See, I won't say this is unexpected, but this is something which is not necessarily covered in your textbooks. Standard textbooks में ये properly covered नहीं है, है ना? But it keeps coming up in the newspapers, if you would have noticed. They keep talking about the role that was played by different members of the Constituent Assembly of India in drafting the provisions of the Indian Constitution. So whether it is K.M. Munshi or whether it is Gopala Swami Iyengar or whether it is Alladi Krishna Swami Iyer or whether it is Sarojini Naidu or whatever, whichever names that you can specifically find and maybe just a single line contribution from them would be enough. See, this is useful also because you can use it in your essay, you can use it in ethics, you can use it probably as introduction in some of the answers related to polity and governance as well. For example, UPSC has asked about the question of the gender perspectives of in the Indian Constitution. जेंडर जस्टिस के लिए इंडियन कॉन्स्टिट्यूशन में क्या प्रोविजंस हैं? व्हाट आर द प्रोविजंस दैट एग्जिस्ट इन द इंडियन कॉन्स्टिट्यूशन विद रिस्पेक्ट टू जेंडर जस्टिस? When you are introducing such an answer, you could simply begin by some contribution that was made by a woman member of the Constituent Assembly of India. That would leave a lasting impression on the examiner. Or maybe when you are concluding your answer, you could leave that. But you don't need to spend a lot of time on this. 15 to 20 minutes, do some Google search, use AI effectively. You will find some of the contributions, some of the important ideas that were proposed by some of these members of the Constituent Assembly, and that's it. Just note it down, either if you're making your notes e-notes or just note it down in your notebook, keep it separately. Right? Anyway, so this is as far as the historical underpinnings and evolution aspect is concerned. Is this clear to everyone? Right? So we'll try to break down every topic like this, and we'll also try to see what are the questions that have been asked by UPSC related to these particular topics in the past that will help us to understand what's happening here. Then, some of the features of the Indian Constitution. So I hope that if you have prepared well enough for prelims examination, this particular topic would not be any kind of a difficulty to you. Some significant amendments to the Indian Constitution. Right? So again, significant amendments would possibly include the first constitutional amendment, would include the, what else, 73rd, 74th, yes, 65th constitutional amendment you could talk about. 52nd constitutional amendment is another significant amendment, the anti-defection law. Right? 101 constitutional amendment, 100th constitutional amendment, 106th constitutional amendment, 102, 103. So prepare a list of some of the most important amendments that have been made to the Indian Constitution. Why? What if UPSC asks you a very straightforward question on the amendment of the Indian Constitution, where they ask you that the procedure for the amendment of the Indian Constitution has been made flexible enough to incorporate the changing demands of the society. In this context, discuss or enlist some of the most important amendments that have been made to the Indian Constitution in last 75 years of Republic. So, you need to have just maybe 10 or 15 constitutional amendments at the top of your mind. Just written down somewhere. Once it's written down in your own words, you have written it down yourself, you will remember it. This is how the preparation for mains has to be done. This way you will cover all your ends for expected and unexpected questions. Expected questions, of course, we can predict on the basis of previous year questions. Unexpected ones we can predict on the basis of analysis of the syllabus that has been provided to us by Union Public Service Commission. Then, further it says significant provisions and basic structure. Now that brings me to, therefore, the next aspect of this. Significant provisions and basic structure. I will simply talk about basic structure here. What are the things that you need to prepare? 2-3 questions have been asked related to basic structure by UPSC in the past. Firstly, you need to know the entire evolution of doctrine of basic structure in India, starting from first Constitutional Amendment Act to the Shankari Prasad case, moving on to Sajjan Singh case, Golaknath case, then 24th and 25th Constitutional Amendment Act, and then moving towards the Keshwananda Bharati case. In this, specifically prepare what doctrine of basic structure is, what are some of the aspects of
doctrine of basic structure. Also prepare what are some of the merits of having doctrine of basic structure. How has doctrine of basic structure helped in preserving the original identity of the Indian Constitution? How doctrine of basic structure has helped in preserving the ideas and the values and the philosophy of the constitution makers. And also prepare on the criticisms. I am expecting a question on this year. I was expecting it last year as well, because this has been in news. Several statements have been made by constitutional dignitaries, including the Vice President of India, criticizing the doctrine of basic structure of the Indian Constitution. So you need to have 3-4 pointers on the criticisms of doctrine of basic structure as well. For example, it has ended up giving way too many powers in the hands of the judiciary. It has made the constitution very rigid in nature. The judiciary, which is unelected, decides whether the changes that have been made by an elected parliament to the constitution are valid or not. This is a doctrine which has no constitutional basis as such. There is no provision of the constitution. There is no debate in the Constituent Assembly that talks about something like doctrine of basic structure. It compromises the idea of parliamentary supremacy in the area of legislation. These are some of the criticisms that you need to prepare. Write those criticisms down, just 4-5 pointers, so that when you are writing tests and when you are in the actual examination hall, you can recollect them easily. If you write it down, it automatically gets embedded here. A lot of times I see students prepare e-notes, which is also okay. But along with e-notes, you need to do a lot of answer writing practice as well. Because when you're making e-notes, you don't necessarily write down everything. You just copy and paste from different sources. Either when you're making e-notes, you type it down yourself. Or the better way would be, in my opinion, write it down. That way you will get writing practice as well. If you're finding it difficult to compile it at one place, you can always take picture from your smartphone and then use any of the e-notes compilation app, whichever you are using. I personally use Evernote, but again, there are multiple apps which are there, right? There are multiple free softwares, there are paid softwares which are available on the internet. You can use any of them. They are available on Android, Apple, they are available on Windows, whatever ecosystem that you are using, right? So that's what my suggestion will be. Rest of course is your choice. Anyway, so Keshwananda Bharati case, prepare this. Then after that, you also need to prepare the provisions of 42nd Constitutional Amendment Act that aim to overturn the provisions or the judgment in Keshwananda Bharati. And then you need to prepare the Minerva Mills case. Again, you don't need to read these things in detail. जितना आपकी text books में दिया है या आपने जहाँ पे भी classes attend करी हैं, that is more than sufficient. But you should have all of this ready at least in your head or in form of 1-page note, right? Because ultimately revision will become very difficult in the last 5 to 10 days before the examination, and maybe when you have that break between the papers as well, if you want to do some revision, it will become almost impossible to do so if you don't have something compiled at one place. So either it has to be in form of your notes, as I said, which have to be compiled physically, or they have to be in form of e-notes, or some kind of way you need to have to revise it all. If nothing, you need to have at least these mind maps. Itna mind map hi bana lijiye kam se kam. So that whenever you look at Golaknath case, that you remember, okay, what happened in Golaknath case was that the court said that the provisions of the fundamental rights cannot be subject to amendment of the parliament. They are sacrosanct in nature. and fundamental rights shall always prevail over the directive principles of state policy. If there is any law which has been made by the state and they are justifying it on the grounds of directive policy being given enforcement, the court would strike down such a law or any such amendment. Why? Because fundamental rights are sacrosanct in nature. They are unamendable in nature. But then 24th Constitutional Amendment Act says that what was said in Golaknath was incorrect in a way. Because what 24 says is that if there is, so there were changes that were made in Article 13 and 368 through 24th, which stated that if there is any amendment that is made of the Indian Constitution under Article 368, then it shall not be subject to the scrutiny of the courts under Article 13 of the Indian Constitution. In Article 13, they stated that if there is any amendment made under 368, this article shall not apply on that particular amendment which has been made under 368. In Keshwananda Bharati case, court upheld this particular. Yes, but at the same time, the Supreme Court of India also stated that there is a limitation of doctrine of basic structure. You can amend any part of the Indian Constitution, including the preamble and the fundamental rights, but any such amendment should not end up affecting any of the basic philosophy or basic provisions of the Indian Constitution in effect. So you want to amend fundamental rights, amend it. But as a result of the amendment, the basic provisions or the basic values of the Indian Constitution should not get compromised at any point of time, which include secularism, which include federalism, which include parliamentary democracy, which include ideas such as rule of law, judicial independence, judicial review, etc. And then another important case that you need to prepare, there is a question which has already been asked by UPSC related to that particular case in 2017, and that was, which case? Yes, the IR Coelho case. So what the court said in IR Coelho case, and what is its relation to Schedule 9 of the Indian Constitution. This is what you need to prepare as far as this particular topic in your syllabus of basic structure is concerned. Okay, is this clear to everyone? Yes? Now, let's move further. See, I'm sure that most of you have anyway done this as a part of your preparation for prelims examination, but for mains this becomes doubly important. Let's move further and let's look at some of the questions that have been asked by UPSC related to these particular topics in the past. Now, this is a very interesting area which UPSC has explored in the recent past, which is the dimension of environment and its relationship with the Constitution of India and the judgments of the Supreme Court of India. So please read the question and then I will discuss with you what are possibly some of the themes that UPSC may touch upon going ahead in future related to this particular aspect. Yes, so this question says, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court of India. What does constitutionalization of any problem means? It means those particular issues and problems have now been made an integral part of the Constitution of India through the judgments of the Supreme Court of India. Discuss the statement with the help of relevant case laws. Now, which means there are two things that you need to draw for. See, we are doing a previous year question analysis. I will tell you what possibly should have been your answer to this question, but more importantly, I want to tell you what you learn from this question. What you learn from this question is that environment and environmental issues have become very important for UPSC. Therefore, now you need to think of what possibly can be other questions in which UPSC can find intersection between environment and the Constitution. Secondly, you also need to be aware of contributions that have been made by Supreme Court of India in various aspects of improving the lives of the citizens or various aspects of social living. These are the two learnings that we need to have. So first, let's talk about, from this particular question, what is the learning that we get for the topics that we need to learn. Isko hata दूं? Yes? Okay. So, what is the learning that we need to make? Firstly, we need to prepare environmental issues with respect to Constitution of India. We need to prepare certain themes with respect to this. For example, one issue that you can prepare is the role of NGT. Prepare what are the functions that are performed by NGT. NGT was actually set up in a way related to the provisions of Article 21 of the Indian Constitution. Since the Supreme Court of India has held that right to clean environment is a part of life and liberty under Article 21, the NGT was set up to deal specifically with environmental related cases separately. So this NGT, you need to know the role of NGT. You need to prepare in this functions of NGT, some of the achievements of NGT as an institution in the past in furthering the idea of right to environment as a fundamental right, and also some of the limitations of NGT as an institution. Right, so this is one aspect that you need to prepare. Second would be federalism with respect to environmental issues. Federalism with respect to environmental issues. So, here you will have to prepare some of the issues that emerge because of India's federal structure related to environmental concerns. There are concerns over river water sharing. There are concerns over the groundwater depletion. There are concerns with respect to climate change. And these issues need to be dealt with through an approach which is cohesive, where we have union and states working hand in hand with each other. So here, with respect to this particular issue, you need to prepare the challenges posed by federalism in addressing environmental issues. You may also talk about what measures are required to enhance cooperation between the union and the states, between the states with respect to the environmental issues. Again, a very important aspect of federalism. Another topic which I feel can be important is fundamental duties and environmental sustainability or environment conservation. What is the role that can be played by the citizens? What is the role that the fundamental duties of the Indian Constitution play in protecting the environment of India? Right? And you need to know some of the important provisions of the Indian Constitution with respect to environment, whether it is in fundamental duties, whether it is fundamental rights or directive principles of state policy. How is Constitution of India furthering or advancing the environmental protection in the country? Now, so some themes that you can prepare. See, this is an endless exercise. Okay, you can keep going into this and keep doing this thing, but I am telling you some of the most important themes in my opinion which need to be prepared. Now, this is one aspect. Second aspect from learning which we can get from that topic is judgments of Supreme Court in advancing certain social issues. Environment, they have already asked, but my suggestion will be prepare some names of 4-5 important judgments given by the Supreme Court of India with respect to environmental protection. MC Mehta versus Union of India, Subhash Kumar versus State of Bihar, the Vellore case, possibly the Union Carbide case, right? So prepare some MC Mehta versus Kamalnath, etc. 4-5 cases के नाम और primarily उन cases में court ने क्या कहा. Just prepare those. Just make a list of 4-5 cases. Similarly, role played by judiciary in ensuring gender justice. So the Shah Bano case and the Shaira Bano case, right? You may also prepare some of the other Sarla Mudgal case, Navtej Singh Johar case, Joseph Shine case. These are some of the important cases in which the Supreme Court of India has tried to advance the idea of gender justice. Another important area, protection of the interest of scheduled caste and scheduled tribes. How have the judgments of the Supreme Court of India helped in protecting the interest of these particular sections of the society? Just prepare 3. Preparation doesn't mean you need to read those cases. No. Just look up on the internet or just take the help of AI to find name of 3 most important cases in which Supreme Court has advanced the interest of scheduled caste and scheduled tribes. And also prepare a 1-line summary of what the court said in these particular cases. That's it. Nothing more than that. That would be more than enough to help you answer any question that UPSC may ask on this. Another topic, disabled. Judgments of the court in order to advance the interests of the disabled people, physically challenged people, whatever may be the politically correct and appropriate term to use here, right? So that's another thing. You could also prepare with respect to children. This is another area which you can essentially prepare. Again, the list is endless. You can go into elderly, you can go into the sexually exploited and this and that and everything, but I think this list should be enough for you to encounter, to be able to deal with any question that UPSC may ask on this particular topic. Now, let's come back to the question that was asked by UPSC. Anyone has any doubts still here? Anyone has any questions? Is this clear to everyone? We are basically trying to understand what we can learn from the previous year questions and understand what else we need to prepare to cover all ends for the mains examination. Now, let's look at the question that was asked by UPSC and quickly try to understand what all we will write in this. ये मैं सब questions के लिए नहीं करूँगा, only for few questions we will do this exercise of trying to understand कि क्या लिखना है answer में. Question was, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss the statement with the help of relevant case laws. Now, let me give you a very brief approach to what I would have written in this kind of a question. Firstly, I would talk about, I want to address that in my approach, I would have written about importance of environmental problems. So I would have talked about climate change and depleting groundwater depletion, and I would have talked about how water scarcity has become a real problem today. If I had some study to quote, I would have written about that maybe. Just to begin, that a recent study has quoted that large parts of India would be facing water scarcity by the year 2050. In this context, addressing such environmental problems in a comprehensive manner becomes really crucial. Supreme Court of India has played a very important role in highlighting these issues and also giving judgments in order to include environmental issues as a part of Indian Constitution. This is what I would have written. So I would have written importance of environmental problems, and I would have linked it with Supreme Court's role in addressing the issue. How has Supreme Court of India done it? I would have then mentioned about some of the important cases. For example, I would have talked about the MC Mehta case, in which the Supreme Court of India has stated that right to clean environment is a part of right to life and personal liberty under Article 21. So, whatever protection that is enjoyed by right to life and personal liberty under Article 21, clean environment also enjoys the same, which means that if the state has to deprive you of environment or clean environment in any way, it has to be done only through a law, and it cannot be disproportionate in manner. It has to be only a reasonable interference which has to be made. I'll give you an example. For example, if the state has to cut down trees for making a highway or for making a hospital or for making an airport, they have to do it only as per a law. And secondly, whatever they do, they have to do it in only a certain amount of proportion. It should not be disproportionate to what they are trying to achieve. You want to construct a highway in Delhi, you cut down some of the trees which are coming in the way of constructing that particular highway. And you possibly do some replantation as well. You don't go and cut trees in Andhra Pradesh for that. You get my point? So that's one example. Secondly, you could talk about, let's say, the Vellore case, Vellore citizens case, in which the Supreme Court of India has laid down the principle of polluter pays. Whatever damage would be caused by a particular polluter to the environment, they would be liable to pay for the compensation and the damages caused to the environment as a result of their actions. So if there is any particular factory that is discharging certain effluents into a nearby river stream, and because of consumption of that particular water, people in the rural communities have fallen sick, that industry would be held responsible and would have to pay the required compensation and the damage to people, those who were affected as a result of that discharge of effluents. Similarly, another case was the MC Mehta versus Kamalnath case. Now, what was this MC Mehta versus Kamalnath case? In this, the Supreme Court of India laid down what is called as the public trust doctrine. Natural resources such as rivers, such as mountains, such as forests, their regulation and their control is with the government, because public trusts them with the control and regulation of these natural resources. If I have trusted you with something that I own, it is your responsibility to use that particular thing in a very, very careful manner. This is what public trust doctrine is. In this case, what happened was that a particular hotel was coming up on the banks of Beas River in Manali, which belonged to a very powerful politician. The government refused to interfere when protests were carried out by the local community. Then a PIL was filed in the Supreme Court of India. The arguments that were made in the court was that, sir, this particular river does not belong to the government, that they can just, or this river bank does not belong to the government, that they can just give away the land to any particular individual for private interest. It belongs to the public. Public has entrusted this natural resource, which is river bank, to the government. It is government's responsibility, because they have been given trust by the public, to ensure that they do not misuse that public trust or that public resource. That is what public trust doctrine is. Do you understand that? Yes. So public trust doctrine that was laid down by the Supreme Court. Similarly, in another case, environmental legal forum case, the Supreme Court of India had given another very important principle. Precautionary principle. Precautionary principle. Does anyone know what is this precautionary principle? This is all something that you need to prepare as a part of your preparation for mains, because these things have already been asked in the mains examination earlier. Yes, precautionary principle, does anyone know? In a way, yes. So, see, at times, I'll give you an example of what precautionary principle is. Let me ask you a question. Let's say you are the environmental inspector or some authority in a particular area where there is a factory. That factory is going to discharge certain effluents into a nearby stream. You go to the factory and ask them that whatever you are discharging, is this harmful? The factory owner says that, sir, we have done study and there is no conclusive evidence in studies that have been performed to show that whatever we are discharging into the river is going to cause any environmental damage. There is no conclusive evidence. But some people from the nearby community come to you and say that in the recent days, since they have started this particular factory's operations, after consuming the water, we have started to fall sick. The factory owner says, no, this is all a rumor. There is no scientific evidence to completely conclusively prove that it is causing any direct damage. It may be due to some other reason. My question is, what will you do in such a situation? You understand the problem? You understand the scenario? It's a classic case study. Here you have to observe the precautionary principle, that you better take precaution than be sorry. If there is something which has potential of causing damage to the environment, even though it has not been conclusively proven, you will take the side of precaution rather than take risk and cause damage to the environment, because that is irreversible in nature. Do you understand what is precautionary principle? These particular principles, polluter pays principle, precautionary principle, the absolute liability principle, that is, absolute liability basically means if there is some damage which has been caused due to your actions to the environment, you will pay full compensation for that. There is not going to be any limit which will be decided by statutory provisions of a law. Union Carbide factory, in case of the Bhopal gas tragedy, in case of Bhopal gas leak, said that hamara to itna hi responsibility banta hai. Supreme Court said no. The damage that you have caused is disproportionate and law is not enough to deal with that. We will use our powers under Article 142 to do complete justice. Because what is 142? 142 is a very important topic for this year's examination. Whenever the law has gaps or whenever the statutory provisions are not able to provide full, complete justice to the citizens, the court will step in and fill those gaps that exist in the law through their orders, through their judgment. That is what Article 142 is. They have the powers to do complete justice in any particular case. Yes. So, Union Carbide factory case was one example of where they invoked 142 to do complete justice. Anyway, so you have to write down some of these things in brief. Once you have mentioned this, Supreme Court's role in addressing the issue through its various judgments, you would talk about that apart from this, the various environmental issues have been made a part of the Indian Constitution through amendments also made to the Indian Constitution. So, conclusion में आप क्या लिखेंगे? You will be writing about possibly the introduction of fundamental duties in the Indian Constitution 51A G. You will talk about this particular fundamental duty. You will talk about inclusion of directive principle of state policy. Which directive principle of state policy talks about the protection, role of the state in protection of environment, forests, etc.? Yes, article, which one? ये आपको याद रखना पड़ेगा. Fundamental rights, directive principles of state policy, you need to remember. At least the most important DPSPs you need to remember, because you can quote them in your answers in ethics, you can quote them in your answers in polity governance, you can quote them in your essay as well. Is this clear to everyone? This is what UPSC is expecting from you in this kind of a question. Yes, it was a slightly difficult question, but let me tell you, if you had been reading newspapers, this question was not that difficult the year when it was asked. I will show you. That year itself, there were number of newspaper articles that had come up, where the newspaper articles had talked about intergenerational equity principle, which had been laid down by the Supreme Court in one of its recent judgments. Public trust doctrine, polluter pays principle. The Supreme Court, through public interest litigation pleas, has been at the core of the evolution of the environmental law in the country. This is an excerpt from the Hindu newspaper. Its judgments have interlinked the survival of humanity to the survival of environment by holding that right to life includes right to wholesome environment. It has nudged awareness in public, legislature and executive by underscoring that clean air and water are indeed attributes of a dignified life. ये ready-made answer है UPSC का editorial से. The court has adapted principles of international law into its verdicts. These include principles like intergenerational equity, by which state is under an obligation to conserve the environment for future generations. Again, the polluter pays principle, by which the polluter has to pay not only the victims of the pollution, but is also liable to repair the damage that has been caused to the environment. The court has brought in the public trust doctrine to hold that the state is only a trustee, holding the wealth safe for its ultimate beneficiary, that is the public. The principle of sustainable development remains a vital check on unbridled expansion. If you write even 3 or 4 of these points, believe me, you will get, out of that 10 marker, you will get 6 points. 6 marks will be there in your pocket. Right? This is again something which came in newspaper only. 2022 is when that question was asked. 2022 is when this particular judgment of the court or this particular news article also came. On Tuesday, Justice Khanwilkar orally said environment must prevail over other rights. उसके अलावा और भी बहुत सारी जजमेंट्स आप बार बार पढ़ते, आपको सिर्फ वो सब लिखने की जरूरत नहीं है. Whatever you have read in current affairs, in mains and prelims, this is the difference. In mains, what you have read in newspapers, you will use that to supplement your answers. In prelims, they may ask a question directly out of what happened in the current affairs. In mains, what you have read becomes your aid to write the answer. That's what you have to remember. So, for example, a few months back, the court had said that rivers Ganga is a living entity. Yes, so that is also nothing but an constitutionalization of environmental problems. What else is that? वही तो है वो, और क्या है? Right? Or the court's judgment with respect to prohibiting the core areas in the national parks, in the tiger reserves from any kind of activity other than ecotourism, other than the communities that live there, is again an example of environmentalization of the constitutionalization of environmental problems, which is being done by the Supreme Court of India through its various judgments. So even if you know some current affairs, you can quote them in your answers in mains examination. But you have to remember, knowing this is not enough. Practicing this and doing this exercise in test series and then finally in the mains examination in UPSC exam hall is what is going to fetch you marks. Anyway, now let's move further. Let's quickly look at some of the other questions also. Okay, I will not be doing this kind of an analysis for all the questions, maybe for some of the questions as I have told you. Another question that was posed in 2022. Right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute in nature. Very simple, straightforward question. You have to write about that how Article 19(1)(d) and 19(1)(e), you have to specifically write that, of the Indian Constitution give right to movement and to reside anywhere throughout the territory of India to the citizens. These rights help in ensuring this. So you will talk about the importance of these particular rights. So you will talk about importance of right to movement. It helps in promoting economic prosperity. It helps in promoting economic mobility. It helps in promoting learning and cultural integration as well. Yes, if I am someone who belongs to Delhi and I am going and living in Chennai, I assimilate some of the culture of Tamil Nadu, and that is promoting cultural integration. I possibly take some values also from where I am from to my place of work, right? Very interestingly, what we saw just yesterday or day before yesterday, so many people across the country were so happy that the Royal Challengers Bangalore won the IPL trophy. I was reading a tweet by someone and they said that the biggest achievement of the RCB team has been that boys in Delhi are shouting "E Sala Cup Namdu" in Kannada here in Delhi. So what could be the best way of integration of the culture that is happening, where people in North India are learning some lines from Kannada, even though maybe just one, but that is enough to promote cultural integration of the country. So right to movement, right to residence, promote that. So you have to write about importance of that, but then you will say, like all the other rights, these rights are also not absolute in nature. Article 19(5) of the Indian Constitution provide powers to the state to impose reasonable restrictions on the exercise of these rights on the grounds of general public interest and protection of interest of scheduled tribes. You will give some examples of that. Inner line permit, you will give example of restrictions put during COVID, etc. and all of that. And then you can further conclude that therefore, as seen above, these rights are important but need to be exercised in a manner so that they don't cause any harm to the public interest. इस तरीके से कुछ आप उसको conclude कर सकते हैं. That's it. 10 marker. But very simple question. But the question is that what are the possible themes that we can expect on similar lines from UPSC in future? So let's quickly talk about that as well. So इसी particular topic से related, what can be the possible themes on which UPSC may ask questions in future? One I feel is freedom of expression. They have already asked a question on this, that freedom of expression is not an absolute right and is subject to certain limitations. UPSC may ask a question related to that in the mains examination going ahead in future. Be ready for a question like that. तो एक तो उसके लिए ready रहिएगा, ठीक है? What else? I had written down some things. Wait, hold on. Anyway, so yeah, so freedom of expression. Secondly, UPSC may ask you about provisions of Article 21 and ask you to explain what is the concept of procedure established by law in the Indian Constitution, and possibly may even ask you to compare it with the concept of due process of law. Procedure established by law, due process of law, Article 21, how these particular changes have been incorporated into the Indian Constitution in the past. What have been the judgments of the court on these particular issues? These are some of the things on which UPSC may ask questions. I'm still looking for it. Where did I write? What are the... Yes. Another question which I feel they can ask on is right to form associations, and how this is also not an unrestricted or an unbridled right, and what are the kind of restrictions that one needs to observe with respect to these particular right as well. Another topic could be fundamental rights versus fundamental duties. In the recent times, there has been a lot of emphasis and talk about that how citizens should remember their fundamental duties before fundamental rights first. Is that correct? Is that not? What are the criticisms of giving more importance to fundamental rights over fundamental duties? What are the criticisms of giving more importance to fundamental duties over fundamental rights? Prepare that particular topic as well. Another important topic is civil liberties or fundamental rights of the citizens and restrictions imposed on them in the name of national security. So when restrictions are imposed on civil liberties such as freedom of speech and expression, personal liberty of the citizens in the name of national security, is this correct? What are the criticisms of the same? There are numerous newspaper articles that keep coming related to it, so you have to prepare that as well. Another question that can possibly come up is related to this only. Various anti-terror laws in India impose a significant restriction on the fundamental rights of the citizens. How far is this correct? Please prepare answers in line with the judgments of the Supreme Court of India, not necessarily on the basis of newspaper articles written in the Hindu. Why? Because in the Hindu, at times the articles may be a bit left-leaning, may be against the state as well, may be more pro-liberty and more pro-freedom, but you have to also understand that you are writing the exam for getting into government services. So it is important that you take the line of what Supreme Court has to say on this matter. That doesn't mean that you say that no, we require anti-terror laws and fundamental rights have no importance. I'm not saying that. Neither should you be saying that only fundamental rights are important and national security is not important. Both are equally important, both need to be balanced very well. So therefore, refer the articles where the judgments of the Supreme Court have been quoted as far as these role of anti-terror laws and their relationship with the fundamental rights is concerned. Is this clear to everyone? Right, we'll come back to this particular topic again because I'll talk about Article 21 as well. Then let's look at some other questions that have been asked by UPSC from this topic. Another question is, Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society. Illustrate with special reference to expanding horizons of light to life and personal liberty. Now, when you read this question, it seems very difficult. But believe me, it is not. All it is saying is that Indian Constitution is not a rigid document. It is a dynamic document which is supposed to evolve organically over a period of time to adjust to the requirements of the evolving and progressive society. तो ये तो हम सबको पता है. You will write that Indian constitution makers had written the constitution in such a manner that it would be an organic document that would keep evolving according to requirements of the society. There are two ways in which the Indian constitution has evolved. One, through amendments which have been made to it by the parliament, and second, through judicial interpretations expanding the horizons of the Indian constitution. Then, because you have to write the answer specially in context of Article 21, you will talk about that, for example, Article 21 that guarantees right to life and personal liberty to all the citizens of India has been expanded continuously through the various judgments of the courts to satisfy the requirements of the society. And then you will write some important judgments of the court through which they have expanded Article 21. But simply judgments लिखने से नहीं होगा, you have to relate it to the requirements of the society. For example, one very big issue that you will write, transgender LGBTQ rights. in today's time, the requirements of gender justice need us to focus on the rights of these marginalized communities. The Supreme Court of India has expanded the ambit of 21 to recognize the right to choose one's sexual orientation in the Navteej Singh Johar case, or has recognized the right to life and basic fundamental rights of the LGBTQ plus community in its NALSA judgment, or in the NAS Foundation judgment. Is this clear to everyone? Second requirement of a progressive society is that people require more and more access to health and education. So the Supreme Court, through its various judgments, has expanded the right to health, nutrition, by nudging the state, by nudging the union and the states to incorporate policies for the improvement of nutrition, for the improvement of the availability of food for the citizens in India. For example, the court has ordered in one of the cases that if you have godowns of Food Corporation of India full of food grains and people are dying because of hunger, it is your responsibility to find that those food grains can reach the plates of those poor people. You may give example of sexual violence against women has become a very important issue in today's progressive society. We want to address that. Supreme Court of India, through its judgment in Vishakha case, expanded the ambit of Article 21 and used its powers under Article 142 in order to give protection to women at workplace against sexual offenses. You will talk about that how informational privacy in today's digital era has become so crucial. There is so much data of each and every individual which is subject to possible exploitation. Supreme Court, through its judgment in Puttaswamy case, has expanded the ambit of Article 21 to include even informational privacy as a part of that right. Are you getting what I am trying to say? You have to write concrete examples. ऊपर से कुछ भी आलतू फालतू लिखने से नंबर नहीं मिलेंगे. You have to write about Puttaswamy, you have to write about sexual violence against women, you have to... See, again, you may think of some other idea. I am telling you that write about informational privacy for a progressive society. You may say that, sir, no, I want to write about right to livelihood. That today how securing livelihood for individuals has become a very important part of a progressive society. So Supreme Court, through its judgment in Olga Teles case, made right to livelihood as a part of Article 21. I want to write about that. Good. Go ahead and write that. No problem. You choose what you want to write about. But write concrete things. Write 4-5 concrete points. Explain them in a line or two. That's it. Nothing more than that is required. That's what UPSC is expecting. That's what the examiner is expecting. And then finally, in your conclusion, you could sum it up all up. Therefore, as we can see, that Supreme Court or the Constitution, in fact, Supreme Court se beyond aap likhenge, Constitution of India has constantly evolved to incorporate the issues of nutrition or gender justice or education or livelihood or environmental sustainability as a part of its ambit. This needs to be further strengthened through the actions of the legislature. For example, what was done through inclusion of Article 21A in the Indian Constitution. So you may sum up your answer by writing something like that. Again, this is not the only approach. If you write the answer, don't think कि मेरे को ऐसा ही लिखना है जैसे क्लास में वो बताया था, सेशन में बताया था. Use your creativity, use your knowledge, use your imagination. I am dead sure you can write 10 times better answer than me. But it will take some time. Initially, when you will write, there will be a sort of inertia which you will have. Initially, everyone feels a mental block to write answers. But over a period of time, believe me, you will be able to overcome all of it. You try it for a few hours, for a few days. Within 4 to 5 days, you will start finding that your pen will start moving on its own. because in mains examination the biggest challenge is you don't really have time. Is that understood to everyone? Yes. Now let's move further. What else? Explain the constitutional perspective of gender justice with the help of relevant constitutional provisions and case laws. Now see, what is the learning that we need to get from this? Identify other topics on which UPSC may ask questions related to this, something like this. Gender justice की जगह कुछ और पूछ लेगा. Question है क्या, देखिए. Question is saying, explain the constitutional perspective of gender justice. How does Constitution of India address the issue of gender justice? You have to explain it with the help of constitutional provisions and relevant case laws. Very simple. Firstly, if I were in your place, in this question, I would have written down the definition of gender justice. So my answer would have begun with defining gender justice. How will you define gender justice? Yes? Can I say it aims at ensuring equity and elimination of discrimination across genders and ensuring a just society irrespective of the gender of a human being? Can I say that? That is what gender justice is. Indian Constitution has incorporated in the original provisions and through amendments various aspects related to gender justice. Can you give me some examples of what are the provisions in the Indian Constitution related to gender justice? Yes? Right to equality. But in that specifically, can I say Article 15 Clause 3 gender justice की बात हो रही है, which means that if there are certain genders which are historically disadvantaged, I need to create a level playing field for them along with others. How will I reach that stage? By making special provisions for the advancement of women. Do you understand that? Article 15 Clause 3 would fall into that category. What else? और क्या लिख सकते हैं? Right? वही Article 14, ठीक है? So Article 14, Article 16, etc. What else? और क्या लिख सकते हैं? Yes. Sorry? Universal adult franchise. Okay. Gender justice पे specifically बात करो. Sorry? Very good. 73rd and 74th Constitutional Amendment Act. What did it do with respect to gender justice? Provided, yes, reservations for women. Reservation for women in Panchayati Raj institutions and urban local bodies. Yes, what else? और क्या लिख सकते हैं? Yes, the constitutional amendment to provide reservations for the women in legislatures. और बताइए. Yes, equal pay for equal work for both men and women. Provisions related to maternity benefit and maternity relief for the women. Yes. Right? You write some of these things. You can also talk about, there is a provision in the fundamental duties as well or not? Which one is that? Yes, to renounce practices that are derogatory to women. Which fundamental duty clause is that? 51A clause? E? E है ना शायद? If I am not wrong, it is E only. (51A clause E). Yes, absolutely correct. 51A clause E. So you write down some of those constitutional provisions and then you talk about how there are various aspects in cases or judgments of the court as well, where gender justice has been given importance. I told you already, Joseph Shine case, Shaira Bano case, Shah Bano case, Navtej Singh Johar case, Sarla Mudgal case, Vishakha case, These are all the cases that are related to the idea of ensuring gender justice in the Indian society. Is that clear to everyone? Now, deriving from this, what are the other issues that UPSC may ask? That is what is more important. So, what all do we prepare? One, I would suggest that you prepare child-related issues. Second, disabled. Third, SC/STs. Fourth, linguistic minorities, very important. Linguistic minorities. LINGUISTIC है, वो थोड़ा सा वो लिखने में हो गया. Anyway, so linguistic minorities. ठीक है.
Are you still juggling newspapers, random notes, and endless PDFs trying to make sense of current affairs? Let's make your UPSC prep smarter. Introducing Digital Current Affairs Premium by Vision IAS, your all-in-one platform to read, revise, and write better every single day. Have a doubt from today's news or something in your syllabus? Just ask and get instant AI-powered answers that are concise, relevant, and completely aligned with the UPSC exam pattern. No more guesswork, no more confusion. Want to boost your mains writing skills? Practice daily with structured questions and get expert feedback to sharpen your content, clarity, and analysis, because writing well is winning half the battle. Need better revision? Use quick notes and highlights to save key points, mark important lines, and organize your current affairs in a way that actually works for you. And here's the best part, some of the most powerful tools are absolutely free. Daily news summaries from The Hindu, Indian Express, and more, curated, filtered, and exam ready. Downloadable PDFs so your notes stay organized and accessible. Daily quizzes and MCQs to reinforce what you've learned and track your progress. A smart student dashboard to monitor your performance and stay on top of your goals. Whether you're just starting or deep into your prep, Digital Current Affairs Premium adapts to your strategy and makes every minute count. So why prepare the hard way when you can prepare the smart way? Visit www.visionis.in/current-affairs and start transforming your current affairs prep today. Because with Vision IAS, you don't just stay updated, you stay.
Prepare, just लिख लीजिए कहीं पे कि what are the important provisions in the Indian Constitution with respect to protection of linguistic minorities. What are some of the important provisions in the Indian Constitution with respect to protection and the upliftment of the SC/STs? What are some of the important provisions with respect to disabled, with respect to children, etc. Anyway, let's move further now. Right to privacy is intrinsic to life and personal liberty, and is inherently protected under Article 21 of the Indian Constitution. Explain. In this reference, discuss the law relating to DNA testing of the child in womb to establish its paternity. Now, two parts of the question. The second part is slightly tricky if you don't really know what was happening and what were some of the developments in current affairs, but the first part is not. Right to privacy, informational privacy is one very favorite topic of UPSC. They have asked at least 3 questions on this particular topic in the past. So it was not a surprise that they asked one in 2024 as well. please try to decipher what the question is. Understanding what the question is saying is the first bit of it. If you don't do that, then rest of this entire exercise is useless. पहले तो क्वेश्चन समझिए. राइट टू प्रिवेसी इज इंट्रिंसिक टू लाइफ एंड पर्सनल लिबर्टी एंड इज इनहेरेंटली प्रोटेक्टेड अंडर 21 ऑफ द इंडियन कॉन्स्टिट्यूशन. You have to basically talk about why right to privacy is such an important right and why it has been elevated to the level of right to life and personal liberty by the Supreme Court of India. This is what you have to write. Your introduction should begin with talking about the K.S. Puttaswamy judgment of the Supreme Court of India, in which the Supreme Court of India held that right to privacy is indeed an intrinsic part of Article 21, and all the protections that are available to life and personal liberty would also be available to informational privacy of any citizen. But the question is why? Why is right to privacy so important? What is the importance of this particular right? ये समझना बहुत जरूरी है. Why is it so important? Why is it so intrinsic to right to life? Think about this. Your right to life includes your right to decide what food to eat. It includes your right to decide what clothes to wear. Right to life and personal liberty include what profession you will take up, includes what life partner you will choose for yourself. It includes what food you will eat today or tomorrow or for the rest of your life, what clothes you will wear, which city you will decide to live in, what kind of a life do you want for yourself. These are all parts of right to life and personal liberty. None of these rights would make sense if someone tells you what you should and what you should not do. If there is intrusion into your decision making process, मैं आज ये खाने वाला हूं, मुझे ये सरकार को बताना पड़े कि क्यों खाने वाला हूं. Why am I going to eat dosa and why am I not going to eat chapati today? If I have to tell that to the government, isn't that a violation of my privacy? And therefore, ultimately, isn't that a violation of my right to life and personal liberty? So you have to explain it that way. That all the other rights which are intrinsic under Article 21 would become meaningless unless I have right to keep the information and the decision making process private to myself. If I want to reveal it, I will tell it to you. If I don't want to tell it, I will not tell it to you, because it is my decision. It also is very important because it gives you autonomy. Any individual, we know there are two meanings of liberty. Personal liberty or liberty can only truly be achieved when a person has fullest freedom to be able to achieve his or her highest potential in life. For that, I need autonomy over my decision making. If the state intrudes into my decision making, it's, let's say the state becomes like a very concerned, over-concerned parent. You're reading something, your parent walks into the room and asks, क्या पढ़ रहे हो? दिखाओ. ये वाला चैप्टर क्यों पढ़ रहे हो? ये वाला क्यों नहीं पढ़ रहे? Invasion of privacy. Your autonomy is being taken away. It means your intelligence is being questioned. That you are not good enough to take decisions on for your life by yourself. State will tell you what you are supposed to do. So your bodily autonomy goes away. Your freedom of choice goes away. Your all the other rights go away. If there is no privacy. That's why privacy is so important. Privacy, you will write fourthly, is also important because in today's day and age, we all are present in the digital world in some form or the other, either through social networking sites or through email or through whatever. And there is a real risk that our information, private life information, may be misused or may be leaked by someone else who has access to it. So there has to be protection which has to be given to it. Same level of protection which has to be given to your life as well. See, no one can take away your life except the state. That too only as per the law. Similarly, no one can take away your privacy as well. What information you want to reveal about yourself to the rest of the world is your choice. And there is a whole lot of information which is present in the digital space today, and that needs protection, and that's why it needs to be elevated to the level of fundamental right under Article 21. You have to write these 4-5 points. Do you understand this? Once you have written about the importance of informational privacy, you have written the importance of privacy as a fundamental right, then the second is, in this reference, discuss the law relating to DNA testing of child in the womb to establish its paternity. So here, UPSC is expecting you to talk about, often there are DNA tests which are conducted on the child in the womb to understand who the father is, to establish paternity. The court last year, in one of its judgments, had stated that this should be done in a very restricted manner only. Say for example, only in rape cases, you should use this. यहाँ पे आपको इस आंसर में पुट्टुस्वामी केस के अंदर सुप्रीम कोर्ट ने जो कुछ प्रिंसिपल्स ले डाउन किए थे with respect to invasion of privacy, you have to talk about those also. For example, in Puttuswamy case, Supreme Court of India said that in order to invade someone's privacy, the state needs to justify or needs to prove 3 things. 1, invasion of privacy should be only done as per a law. If invasion of privacy is done as per an executive action alone, it is unconstitutional. For example, if I have to, you're communicating on phone. If I tap your phone line, I cannot do it if there is no law that exists to do so. I can do that only when there is a law. Is that understood to everyone? Secondly, I have to prove that when I am invading your privacy, this is for achieving some legitimate purpose of the state. I'll explain to you. One legitimate purpose of the state is to maintain national security. The police agencies feel that you are communicating with the terrorist and planning a terrorist attack. Can they tap your phone line? Yes. But they will have to first show that there is a law to do so. They will have to do it as per a law, and they will have to do it for achieving a legitimate purpose of the state. But let's say your phone line has been tapped. You ask the police officer, why was my phone line tapped? And the police officer says that I have come to know that you have been talking to my daughter. And there is something going on between the two of you. I want to stop that from happening. Is this a legitimate purpose of the state? To stop two grown-up individuals to decide whom they should be talking to and whom they should not be talking to? Can the state invade your privacy for that purpose? No. It's not. ये कोई legitimate purpose थोड़ी ना है कि दो प्रेमी पंछियों को जो है state रोकेगा बात करने से. That is not the legitimate objective or the purpose of the state. So, this invasion should be done only to achieve a legitimate purpose of the state. So you have to write about these things as well, because in the Puttuswamy judgment, Supreme Court of India has given these protections to right to privacy. and the third is proportionality. Whatever invasion you make has to be proportionate to the objective that you are trying to achieve. I have come to know that you are communicating with the terrorists over a phone line. But what I do is, I not only tap your phone lines, but I tap the phone lines of all your family members as well. You work for an organization, I have tapped their phone lines as well. I have seized their accounts as well. This is disproportionate action which is being taken. What the Supreme Court said, that what you can achieve, you don't use a sledgehammer to kill a fly. आप एक मक्खी को मारने के लिए कुल्हाड़ी नहीं यूज करते. जितना रिस्ट्रिक्शन या इन्वेजन करना है उस पर्पस को अचीव करने के लिए उतना ही कीजिए, नथिंग मोर देन दैट. सो इट हैज टू बी, इन्वेजन हैज टू बी, should be proportionate to the objective sought to be achieved, to the objective desired to be achieved. These are the three things which you have to mention. These are three aspects of principles that have been laid down by the court in the Puttaswamy case in order to justify the invasion of privacy by the state of any individual. So, on the basis of that only you have to write here that DNA testing for establishing the paternity of a child in womb can be done, but it should conform to these three particular principles. So, only in exceptional cases, for example, in cases of rape, when you have to establish the guilt of any particular person, should this particular principle be invoked. Otherwise, what the court said was that this can cause the invasion of privacy of an unborn child. Uski bhi to koi right to privacy hai. And it can also cause trauma to the pregnant woman also. So it is invading her privacy as well when you are conducting a paternity test like that. So it should only be conducted in limited circumstances. If you'd been reading the newspapers, you would have had some idea आप कुछ लिख पाते इसके अंदर. This was the second part of the question, of course, was slightly difficult, I would say. Anyway, is this clear to everyone? Yes? Now, so अभी इसी से related और क्या आप questions आ सकते हैं in future, in examination? See, firstly, right to privacy is very, very important, in my opinion. UPSC can ask a question on right to privacy versus national security as well. I've already told you, prepare questions related to freedom of expression. You may find questions on the freedom of expression versus regulation on social media. How much of that should happen, how much of that should not happen. You may also find questions on freedom of speech and expression and regulation of OTT platforms. See, OTT platforms need to be regulated, but they don't come under any specific law as of now in India. They are regulated as per certain rules that have been made under the IT Act by the government. So do we need a comprehensive law in order to regulate the OTT platforms? Yes. Just like how we regulate the content on the television or on the radio. But there is a danger as well that it may end up curbing artistic freedom, creative expression, freedom of speech and expression. So we need to have a very balanced and a nuanced approach with respect to this particular issue and topic. So prepare that issue as well. Is that clear? Anyway, let's move further now. Yes. Yes, of course. Read the relevant newspaper articles, editorials that have come related to this issue is what I would suggest. And just like, even if you don't like make notes out of it, at least like take 2-3 points out of it and write somewhere, so that it's there in the back of your mind of what you have to do in the exam. Okay? Okay, now, So again, see, gender justice and all of that, all those things had been in news, and that's why UPSC had asked this question 2 years back. I will move further. We've like spent quite a lot of time on this topic. Now, anyway, this topic, separation of powers between various organs, dispute redressal mechanisms and institution. This is a very important topic. On this topic, UPSC has asked questions like, what is separation of powers? What is the importance of separation of powers? They have asked questions like, what are the provisions in the Indian constitution that ensure separation of powers? What are the constitutional provisions that dilute separation of powers? And then, what is the alternate to the strict separation of powers in Indian constitution? We have a system of checks and balances. We don't have strict separation of powers like US, but what we have is system of checks and balances. So in this particular topic, I'll tell you what are the things to be prepared, but if you just quickly look at the weightage of this topic, usually one question is asked from this topic every year. This is one question that was asked. I would say that this falls in separation of powers as well as this question falls under the functioning of the executive as well. Discuss the essential conditions for the exercise of the legislative powers by the governor. Discuss the legality of repromulgation of ordinances by the governor without placing them before the legislature. Two parts of the question. What are the conditions that should be met when the governor exercises ordinance making powers? Secondly, discuss whether the governor is placing an ordinance in front of the legislature for repromulgation or bringing into effect again without putting it in front of the legislature and getting the approval of the legislature. Two parts of the question. Now, I will firstly talk about this question and then I will talk about what are the things that you need to prepare as a part of preparation for separation of powers topic. In this question, you can begin by talking about Article 213 of the Indian Constitution, how it gives powers to the governor to promulgate ordinances when both or when both the houses of the state legislature are not in session. In case there are both two houses, in case of just one house, the legislative assembly is not in session, right? Both the houses have to be in session for the law to be made. If even one is not in session, ordinance can be promulgated. Now, this power, as per the constitution, is a temporary power. So in your answer, you will talk about Article 213, explain that. Secondly, you will talk about the nature of ordinance, how it is supposed to be only a temporary provision. Therefore, certain conditions have been put on the exercise of this power by the governors of the state. First essential condition is that it should be exercised only on the aid and the advice of Council of Ministers. It cannot be exercised as a discretionary power by the governor. Secondly, it should be exercised only when both the houses, in case of a bicameral legislature, and legislative assembly is not in session in case of a single legislative body in the state. Third, such an ordinance would go out of effect 6 weeks after both the houses of the legislature reassemble. So it is temporary in nature and it has a temporary life of only up to 6 weeks from reassembly of the legislature. What else? If the law, if passed by the legislature, would have required the consent of the president, assent of the president for it to become effective, had it been a law of the a bill of the legislature, if it had required the assent of the president to come into effect, then the governor cannot promulgate the ordinance without taking the assent of the president. So, assent of president is mandatory if the legislative bill would have required the same. Now here there are two things. There are some cases in which a state legislature can make a law only if the bill prior to the introduction in the legislature has received the recommendation of the president. Constitution has certain provisions. If you read provisions, for example, related to Article 304, if there is a bill which has to be introduced to regulate interstate trade and commerce in India, before introduction in the legislature, it requires approval or assent of the initial recommendation of the President of India. So अगर ऐसा कोई bill आप ordinance के through pass करेंगे, for that you require recommendation of the President. Or if the law, if brought into effect, would have required the recommendation of the President, then in that case also you would have had to send that particular ordinance to the President of India for his recommendation. I will straight away read out the provisions of Article 213 of the Indian Constitution for you, because that is where these conditions have been mentioned. See, 213 says that, provided that the governor shall not promulgate without instructions from the President any such ordinance if the bill containing the same provisions would under this constitution have required the previous sanction of the President for introduction of the bill into the legislature. Second, he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President. Let's say, we all know that in certain circumstances, the governor of a state can reserve a bill for the President of India when he thinks that there is national interest that is involved. And in such a situation, the governor, before promulgating the ordinance, needs to send it to the President of India for receiving his assent. An act of the legislature of the state containing the same provisions under this constitution would have been invalid unless, having been reserved for the consideration of the President, it had received the assent of the President. So such a law would have been invalid unless it would have received the assent of the President of India, if it had been a legislative bill. So ordinance would also need to go through the same procedure. So ये तो हो गई essential conditions. Now then is the second part of the question. You have to simply talk about the DC Vadhava case. That in the past there have been certain instances where the state governors have promulgated ordinances, same ordinance multiple number of times without taking it through the scrutiny of the legislature. Before the expiry of the 6 weeks period, the legislative session was called off and the ordinance was repromulgated. Now, in DC Vadhava case, the Supreme Court of India had stated that repromulgation of an ordinance, if done due to ulterior motives, would be held as unconstitutional, which means that promulgation of an ordinance is also subject to judicial review. The Supreme Court in DC Vadhava case said that you need to have justifiable reasons for repromulgation of an ordinance. If it is just done in order to escape the scrutiny of the legislature, it is unconstitutional. This is important. Please remember, I am saying this because in many books and in many material, including ours as well, it has been wrongly mentioned that repromulgation of an ordinance is unconstitutional. That is not what the court stated in DC Vadhava case. The court had stated that repromulgation of an ordinance, if done in order to escape the scrutiny of the legislature, would be held as unconstitutional. If the executive can justify that repromulgation was done due to increased burden of work on the legislature or due to a short period or short duration of the legislature session, because of those reasons, if you repromulgated ordinance, it is okay. But see, this is a flaw with the judgment. Why? Because now it gives an excuse to the executive to repromulgate ordinance by saying that we were too busy with work, or by calling a short session of the legislature deliberately. Because ultimately, who decides the duration of the legislative session? Executive, Council of Ministers, they can call for a short session and re-promulgate the ordinance and say that session बहुत छोटा था पर आपने ही तो session छोटा बुलाया. Or they can say that कि नहीं, there was other legislative business, because of that we were not able to consider this particular bill in the or ordinance in the legislature. आपके पास priority थी, आपके, because executive only decides the agenda of the parliament or the legislature. You could have decided to put that bill in the first priority. Why didn't you do that? So there is a flaw with the judgment as well. Anyway, I hope that this is understood to all of you. This year, expect a question. Of course, you have seen in prelims they have already asked question. Expect a question on federalism vis-a-vis the position of governor. I am very, very, very hopeful that they will ask a question on it. That how governor creates, a position of governor has created tussles in the functioning of Indian federalism. How it was supposed to be the, one could say, the linchpin of Indian federalism, allowing coordination between states and union, but it has ended up creating problems as well and issues. And what are the reforms which are required in the office of the governor in order to address those particular issues? UPSC may ask a question on that. Is that clear to everyone? Yes. Now, let's go further. I'll come back to this question later too. Okay. Yes, functions, responsibilities of union and states, issues and challenges pertaining to federal structure, devolution of power, finances up to local levels and challenges therein. In this particular topic, my suggestion to you will be, I'm not giving any list of possible questions or themes that can be explored because ye endless hai. In this, my suggestion will be, especially as far as the local bodies are concerned, prepare the answers for all the questions that UPSC has asked in last 12 years in mains examination related to local bodies. Even if you do that much, you will be able to deal with any question that comes in the examination this year on local bodies. Because what are the questions that UPSC asks? Their questions are usually the similar kind of things. States have not devolved enough functions to local bodies. States have not devolved enough finances or financial powers to the local bodies. The local bodies, despite the decentralization, have failed to effectively function, effectively. What has been the impact of the setting up of the local bodies on governance, on good governance? What has been the impact of the local bodies and reservation provided on the status of women in the rural society? How far have the urban local bodies in India been able to cater to the demands of the urban areas and the increasing urban population in the country? These are the similar kind of themes that you will see UPSC asks related to that topic. First, let me address that, then I will come to the next one. On this topic, you can see every year at least 2 to 3 questions are asked. Federalism and local governance are perhaps the most favorite themes of UPSC. You will find every year at least 1 question from local governance will be there in the mains examination, and federalism also there will be at least 1 or 2 questions. So let's first look at questions related to the theme of local government. In 2022, they asked, to what extent, in your opinion, has decentralization of power in India changed the governance landscape at the grassroots? So, to what extent? The question itself is basically saying that you analyze and assess whether it has truly achieved its purpose or not. Firstly, I would have began the answer by talking about what is decentralization of power. Power has been given from the top to the lower bodies to take decisions, to make plans and to implement those particular plans. Primarily 2 powers have been given to local bodies in India. 1, formation of plans. 2nd, implementation of plans and schemes for social justice, economic development. Both local and urban bodies, rural bodies and urban bodies have been given these particular functions. Making and formulation of plans for social justice and economic development, and implementation of schemes and programs and those plans for economic justice and social justice and economic development. So you explain what is decentralization. You will explain about 73rd and 74th how that has done this decentralization. Then you have to assess. So first you talk about what is the kind of impact it has had on improving the grassroots governance. What all things can you write? One, you can write it has led to inclusive governance at the grassroots levels. Why? SC, ST, women. Reservations been provided compulsorily. Is that clear? It has, you can separately mention it has led to women empowerment also. Women have now become an equal stakeholder in governance in the rural areas. Some of the women sarpanch have done tremendously well in improving the developmental indices in the areas under their leadership. Third, this has led to better planning and lesser wastage of resources in the grassroots areas, in the rural and local areas. Why? Because who knows the priorities of development better than the people themselves? So, what are the points that you can write here? One point that you can write about is inclusive governance, women empowerment, participatory planning, of whom? You can write that. Inclusive governance में से वो include हो जाता है, but you can write that. ठीक है? Less wastage of resources. You can talk about effective monitoring. Governance की बात हो रही है ना? Monitoring has become more effective. Leakages and corruption in schemes has reduced. Social audit has become a very powerful tool to highlight some of the wrongdoings at the local levels in governance. So those are some of the things that you can essentially talk about when you're talking about this. You can talk about improved service delivery. इसमें कुछ ना examples of schemes etc. also you can give. You can give example of Pradhan Mantri this Gramin Awas Yojana. You can give the example of MG Narega, how their implementation is improved. So it has led to more effective or improved service delivery as well. But you have to talk about to what extent. So which means you have to talk about some of the limitations as well. I didn't get you. Local governance की बात हो रही है सर. Decentralization of power in India has changed the governance landscape at the grassroots. सर उसकी इम्प्लीमेंटेशन की मॉनिटरिंग जो है, एमजी नरेगा की जो मॉनिटरिंग है वो कहां पे हो रही है? कौन कर रहा है वो? पंचायत को पावर दी गई है आइडेंटिफिकेशन ऑफ बेनिफिशियरीज की. कौन कर रहा है आइडेंटिफिकेशन ऑफ बेनिफिशियरीज? प्रधानमंत्री तो नहीं कर रहे ना बैठ के लिस्ट बना रहे, चीफ मिनिस्टर तो नहीं बना रहे लिस्ट, ग्राम सरपंच बना रहा है वो लिस्ट, है ना? दैट इज व्हाट वी आर टॉकिंग अबाउट. सो लीकेजेस हैव बिकम लेसर, इंप्रूव्ड सर्विस डिलीवरी, grievance redressal mechanisms are stronger. Planning is much better because people in the rural areas or in the local areas know what are their priorities better than the priorities of the others, than someone else. That's what we are talking about. Okay? So talk about these, but you talk about limitations. So you will talk about that they have not been given enough finances, fiscal devolution is not enough. In absence of that, despite having the powers to make plans, they cannot necessarily implement them. You may talk about that they have been given planning powers, but they have not been given enough training. So planning ki power hai, but when you don't have resources to carry out the planning exercise, then also it's a problem. Yes, you may also talk about how there is at times political interference also that is made by the senior politicians in the state in the functioning of these local bodies, which affects their functioning in an effective manner. So those 3-4 points, whatever funds, function, functionaries के terms में जैसे भी आप उसको लिखना चाहें, you can talk about that. Is this clear to everyone? See, here I have taken more from the perspective of the rural governance, but it is not limited to that. You can always talk about urban governance as well in this. Okay, now let's look at some of the other questions that have been asked from this particular topic in the past. See, if you see what I was telling you, UPSC in related to local governance has asked questions, and if you just cover those themes itself, it would be more than sufficient for you to cover this topic entirely. The local self-government has not proved to be effective instrument of governance. Critically examine the statement and give your views to improve the situation. It is actually, if you look at it, nothing but same question that was asked last year. To what extent, in your opinion, has decentralization of power in India changed? हाँ, ये 2022 और 17 वाला question almost same है. Then, the strength and the sustenance of local institutions in India has shifted from their formative phase of functions, functionaries and funds to the contemporary stage of functionality. So earlier, the issue was that they don't have enough funds, or they don't have enough, they've not been given functions, or they don't have functionaries. But despite that, despite now funds being given, despite now some devolution being done in terms of functions as well, they still remain dysfunctional. Why? You have to talk about that. Why? Because bureaucracy is still reluctant to share powers with the local bodies. Why? Because the funds that have been devolved are not enough to meet the requirements of the local bodies. So it is not really leading to any functional purpose for these local bodies. Funds to hain, but are they enough to ensure functionality? No. Functionaries to hain, but do they have enough training to be able to ensure functionality? No. Functions hain, but you have created other parallel bodies in the state. For example, to the provisioning of drinking water has to be done by the urban local bodies, municipalities. But in many cities, in many states, you have created parastatal bodies, such as in Delhi, you have Delhi Jal Board, which is supposed to be responsible for providing clean drinking water to your household. So what is Delhi Municipal Corporation going to do if Delhi Jal Board is going to take care of that? Delhi Developmental Authority is supposed to be developing the urban areas in Delhi. If they will do that, then what will the developmental functions be carried out by the Municipal Corporation of Delhi? Urban transport should have ideally been the responsibility of Municipal Corporation. But you have created another corporation of the Delhi government, Delhi Transport Corporation, DTC. They run buses under the Delhi government. So, functions diye to hain, but not enough functions to be able to perform their powers, to perform their functions properly. So, they are dysfunctional bodies. That is what has to be written. Anyway, then what else? Another question, 2023. This time they asked specifically on urban local bodies. You can't write about panchayats. The states in India seem reluctant to empower urban local bodies both functionally as well as financially. The states in India seem reluctant to empower urban local bodies both functionally as well as financially. Same, you have to prepare a list of some examples of how the states have been reluctant to give functions, finances and the functionaries to the local bodies, both urban and rural. For example, you can mention that today only less than 5% of the funds of the local bodies are generated through their own sources. 95% of their funds, they are dependent on either the transfers from the center or the state. The taxation powers that have been given to them are not enough, which means that whenever they get fund from state or center, they come with conditions. So they don't have enough autonomy to decide what they should be spending the money on. Secondly, even those particular taxes that have been given to them have not been utilized properly by the urban local bodies themselves. Property tax is one of the most important sources of revenue for the urban local bodies across the world. But in India, it forms a very minuscule percentage of the overall revenue of the urban local bodies. So you have to write about that. Why? Because one, there are too many exemptions that are provided by the government with respect to collection of property taxes in India. And secondly, because digitization of land records has still not been done properly, collection of these property tax remains very poor. Administrative issues bhi hain, because these urban local bodies, administrative authorities are not well trained enough in order to collect the property taxes in an efficient manner. So there are a lot of leakages which are there. You may also give some quote from some of the studies performed by Government of India, where they have said that the urban local bodies would require almost 3% of India's GDP in form of investment in order to deal with increasing pressure of urbanization in India. But as of now, they get less than 0.5% of India's GDP in terms of revenue, in terms of funds for meeting their requirements. In such a situation, you cannot expect to become a high growth economy, because what will start to happen? Many people will start migrating out of the country in search of a better living standards. Because your urban areas, if you don't improve the air quality, water quality, if you don't improve the roads, if you don't improve the basic civic amenities, people, those who are talented, people, those who have opportunity, will fly out of the country and will go and settle somewhere else. Because life is poor here. So if the country has to continue to keep growing, you need to have a good quality of life as well in the urban areas, and for that, the urban bodies need to have substantial amount of funds. Similarly, you have to talk about functions as well. Examples of Delhi Jal Board or BBMP. So in Bangalore also, the Bangalore Municipal Corporation does not have the powers with respect to development of the urban areas in Bangalore, because there is Bangalore Developmental Authority, very similar to the DDA in Delhi. The KSRTC, Karnataka State Road Transport Corporation, is supposed to be responsible for, or BMTC, Bangalore Municipal Transport Corporation, is supposed to be responsible for managing the urban transport in the city of Bangalore. And it is not being done by the urban local body themselves. So their function is not there in their hand. So those kind of things you have to write about. Anyway, let's move further. 2024 में देखिए उन्होंने क्या किया, बड़ा एक इंटरेस्टिंग चीज करी. I want you to see this question. We'll spend just 2 minutes on this question. Analyze the role of local bodies in providing good governance at local level and bring out the pros and cons merging the local bodies with urban local bodies. 2 parts of the question. Analyze the role of local bodies in providing good governance at local level. So they have now married 2 concepts, good governance and local governance. So how will you write the answer? You have to think, what are the aspects of good governance? Participatory decision making, openness, transparency, accountability, responsiveness, right? इसी तरीके के तो elements हैं, those 8 elements of good governance. So how does local governance ensure good governance? So think about it. How does local governance ensure accountability? How does local governance ensure accountability? Through social audits, through identification of beneficiaries. They are promoting participatory decision making in the government schemes and programs. Through participatory plan preparation, they are promoting participatory governance. How are they promoting responsiveness? By ensuring that the decision makers are very close to whom the decisions are made for. You are ensuring responsiveness as well. So promoting good governance. Good governance is promoted through various efficiency and effectiveness measures as well. How does local governance promote that? By ensuring minimal wastage of resources. Why? Because if planning would be done as per the requirements of the people, wastage of resources would always be less. If the Prime Minister says give 500 crore to this village, there will be wastage of resources. But if the village says that we need 5 crore rupees for this purpose, utilization of resources would be much more effective in nature. Leakages would be much more effective, which be much lesser in the government schemes and programs. So you understand what UPSC is doing here. It is not a complicated question. They just want you to know local governance kya kya karta hai, and they want you to know what are the elements of good governance. Just relate these two. It's an application based question. Second part of the question is even more interesting. They are saying that what if we merge urban local bodies and rural bodies and make them into one? So bring the pros and the cons, merging the rural bodies with the urban local bodies. Now think about it. If you merge these bodies, you will have more resources at your disposal. Yes. So this shortage of resources issue may be addressed. You will have more functionaries as well at your disposal. Also, you will say that today it's very difficult to often distinguish between urban and rural areas. There are some areas which are neither completely urban nor completely rural. They are semi or peri-urban areas. You go to the outskirts of Delhi, you go to some of the places in Gurgaon, you will see that right amidst the tall buildings in Gurgaon and skyscrapers, you will find some people, those who are literally living a village life. In Delhi also, many areas you will find that. So, if you have an integrated approach, you will be able to serve these areas better. Also, you will be able to build a more comprehensive policy in order to prevent out migration from rural areas into the urban areas and make urban areas more livable. So these kind of points can be written, but there are cons as well. It's possible when you will merge these bodies, their entire focus may just be on urban areas, considering that urban bodies will eat the rural bodies for breakfast any day. Do you understand what I'm trying to say? आप दिल्ली म्युनिसिपल कॉरपोरेशन को जो दिल्ली के साथ में कोई गांव लगता है उसकी पंचायत के साइज से कंपेयर ही नहीं कर सकते. तो जब बॉडीज मर्ज हो जाएंगी एंड व्हेन द मेंबर्स ऑफ म्युनिसिपल बॉडी ऑफ दिल्ली and the rural body of that local panchayat will sit together, do you think anyone will pay heed to the concerns and the problems of the local panchayat? So it's possible that the challenges and the problems of the local areas in the rural parts may be completely ignored. It may lead to political tussle as well. So it will be politically also challenging how you will merge these bodies. It may lead to some kind of chaos and confusion also in the early stages. So this is also another big problem which is there. Ultimately, if I were in your place, I would write the conclusion that before merger of these, considering the merger of these bodies, we need to make these bodies independently functional. Only then joining them would make more sense. Otherwise, it would create a chaos only. You're not really solving the problem by merging two bodies. Also, accountability may diminish. Why? Because अगर एक body होगी, let's say for Delhi and the surrounding rural areas, accessibility for people in rural areas will become more difficult. Why? Because now there will be one single central body. Earlier they had access to the local panchayat which was just next door, but now their access would go away far from them. Is that understood? So this is what has to be written. Anyway, Another question related to theme of federalism now, 2023. They asked related to 356 and the decline in the use of 356. This is the 1990s legal and political factors responsible for it. SR Bommai judgment, Rameshwar Prasad judgment, the presidential activism, rising media activism in the country. All those things have to be written. How the Supreme Court has multiple number of times said that we can not only review the imposition of 356 but can even reverse the situation. They have done that in case of Uttarakhand and Arunachal already. So what stops them from doing the same in case of the other states in India as well is something which we need to keep in mind, and that's why there has been a decline in the use of 356. This year, because we have completed 50 years of national emergency, expect a question on national emergency, provisions related to 352. So prepare them. Two kind of questions can be asked. One, salient provisions or effects of invoking 352. UPSC has already asked a similar question with respect to 360 earlier. And second question could be, how has the 44th Constitutional Amendment Act helped in preventing the misuse of the national emergency provisions under Article 352 since 1975? Is that clear? Two questions possible. Impact of 44th, and secondly, generally what are the effects of invoking the provisions of Article 352 on the fundamental rights, on the life of the legislature, on center-state relations in India? Please prepare that. Then, so again, this was in news significantly, and that's why this had come. I will not be surprised that they ask a question on 352 this year, because again, it has been news and the government also kept talking about it a lot. Then, GST, somehow, I don't know, like UPSC pulled it out suddenly again in 2023, almost 5 years, 6 years after this particular act was brought into force. But I don't think that now they will ask a question. But again, look for themes in newspapers related to federalism. Questions will be there. Governor wali theme definitely important hai, isme koi doubt nahi hai. I think another area where UPSC can ask question this year on the theme of federalism is delimitation. So several comments have been made by leaders from different political parties. So related to federalism, the themes that I expect the questions to appear in the examination this year are: one, governor; second, related to the issue of delimitation; also please prepare something with respect to financial devolution as well, sharing of taxes, cess, surcharge, financial issues between union and states. Fourth, prepare a topic on moving subjects from state list to concurrent list. There is already a conversation going on around shifting subjects such as the public order to concurrent list. Similarly, another topic which could be of interest would be, do we need to revamp Schedule 7 of the Indian Constitution? Revamping Schedule 7, because it does not include a number of new subjects that are coming up in governance today, including artificial intelligence or cyber security, etc., and all of those things. And ideally, we need to have a conversation about it, whether the union should continue to use the residuary subject powers and claim all of these subjects to be under its control, or should we have a broader discussion on it. I also expect a question on whether we should have smaller states in India or not this year. $356 भी थोड़ा बहुत न्यूज़ में तो रहा ही है, especially because of Manipur and the situation there, but I don't think that they will ask a question on 356, but still थोड़ा बहुत तो प्रिपेयर कर ही लीजिएगा. Now let's get back to this. We don't really have much time, 5 minutes, but I mean it was too difficult to cover all of this and then this jitna bhi kar sakte hain dekhte hain. Yes, see, now this question is very interesting. 2024. What changes has the union government recently introduced in the domain of center-state relations suggest measures to be adopted to build the trust between center and states and strengthening federalism? फेडरलिज्म का ना पूरे एक टॉपिक को ढंग से प्रिपेयर कर लीजिएगा. उसमें चीज़ें क्या प्रिपेयर करनी है? What are the provisions of the Indian Constitution that promote federalism? What are some of the provisions of the Indian Constitution that are in favor of unitary system or which promote unitary powers over federalism? Third, prepare what is cooperative federalism, competitive federalism. What are the provisions in the Indian Constitution that promote cooperative federalism? What are some of the challenges in Indian federalism and its functioning? And then what steps have been taken in order to strengthen federalism? तो ये देखिए वो क्वेश्चन आया, what changes have union government recently introduced? Recently introduced में बहुत कुछ आ जाता है recent में, है ना. नीति आयोग is also recent if you look at it that way. GST and the compensation that was supposed to be provided to the states for the loss due to the implementation of GST is also an example which you can bring in here. You can also bring in the example with respect to the pruning down of centrally sponsored schemes. Number of centrally sponsored schemes have been brought down to give more autonomy to the states. The increased devolution to the states from the divisible pool of taxes on the recommendation of the Finance Commission. Right, so all those points can of course be mentioned here, steps that have been taken in order to strengthen federalism in India. And then it says, suggest measures to be adopted to build the trust between center and states and for strengthening federalism. So, ये एक standard list है, just prepare these particular topics. Anyway, let's look at the next one. This one is executive and topic related to your strengthening and functioning of the judiciary. This year, I expect a few questions on judiciary. One, please prepare the topic of collegium. It has been in news. It has been subject to criticism. So please prepare on evolution of collegium system. What are the criticisms of collegium system? What have been some of the benefits of the adoption of collegium system in India for appointment of judges to the higher judiciary? Secondly, also prepare provisions related to Article 142. What is it? What is its importance? And does it lead to judicial overreach? So, iske some basics, importance, and some of the examples of the judgments in which the Supreme Court has invoked them. And lastly, also, what are some of the concerns, especially related to judicial overreach with respect to collegium system? Is that clear to everyone? Secondly, you should also, not collegium, Article 142. Thirdly, also prepare on the diversity in judiciary. UPSC has already asked a question on lack of women representation in judiciary. Possibly prepare a topic on the diversity in judiciary as well. Another very important topic for this year's exam is judicial accountability. What is judicial accountability? What are the provisions for ensuring judicial accountability in India? What are the limitations of these particular provisions? What are the reforms that are required in judicial accountability standards or measures to be adopted in India? UPSC has already asked a question in 2023 that constitutionally guaranteed judicial independence is a prerequisite of democracy. It's saying that judicial independence should be guaranteed by the constitution. has to be within the provisions of the constitution to ensure democracy. So you have to firstly talk about why judicial independence is important, and that too why including it in provisions of the constitution is important. Judicial independence is important because judiciary is the ultimate interpreter of the constitution. So in order to maintain the sanctity of the constitution. Judicial independence is important because the executive is often a litigant in the courts. If the judiciary would not be independent, then people would lose faith in the judicial system of the country. In order to maintain the idea of rule of law, that irrespective of who you are and what you are, if you are violating the law, you will be subject to same punishment of the law as anyone else would be. That is also an idea which is maintained by the judicial independence. Judicial independence is also very crucial because often states and union and states get into conflict with each other. If judiciary would not be independent, then in that case federalism would not remain intact. Judicial independence is also important to ensure democracy because often election disputes related to election matters are also decided by the judiciary. So if judiciary would not be independent, then people would lose faith in the election process of the country. So all those aspects you have to write. See, there are two ways to write the question. Either you talk about what are elements of democracy which are protected by judicial independence, or you go the other way, that how judicial independence protects certain elements of democracy. Whichever way you may want to write it, it's your choice. But you have to specifically talk about why provisions of the constitution must protect it. And that's why you list some of the provisions of the constitution that protect independence of judiciary in India. Yes, their salaries are charged expenditure on the consolidated fund of India or consolidated fund of the state. Their conditions of office cannot be reduced to their disadvantage once they have been appointed. The impeachment process has been made extremely difficult and they can be removed only as per a resolution that has been passed by both the houses of the parliament and an order issued by the President of India in the same session in which both the houses of the parliament have passed a resolution by a special majority. Right? So judicial independence को ensure करने के लिए constitution में क्या क्या provisions हैं वो थोड़ा बहुत लिखना ज़रूरी है. Anyway, let's just run through this now. I mean, we don't have any time left, but still. Explain the reasons for growth of PIL in India. As a result of it, has the Supreme Court emerged as world's most powerful judiciary? We have discussed this question earlier as well. I'm not going into it. Okay, let's look at maybe something which is of more practical utility for us. Parliamentary functioning, I really don't know what kind of a question may be asked this year, but look at all the previous year questions, I would say. Questions on diminishing power of individual legislator, questions on disruption in the parliament, question on role of committees in ensuring strengthened functioning of the parliament. Maybe also look at the topic of pre-legislative consultation as well. That how the pre-legislative consultation that is performed by the various ministries and departments of the government before the introduction of the bill in the parliament or before the rules are finally formulated, delegated legislation. जो rules बनाती है government, ministries, उनको आजकल it is mandatory for them to place it in public domain for inviting comments. So how that is also a very important provision in order to ensure accountability of the executive to the parliament and to the people of the country. Please read about that as well. Another important topic. Yes, comparison of constitution पे आ जाता हूँ मैं जल्दी से. I'll finish up with this particular topic. Comparison of Indian constitution with the other countries. UPSC till now has explored a few themes. Let me tell you what else they can ask so that at least you know what all to prepare. So, comparison. Let's first talk about India-US. Senate versus Rajya Sabha. Prepare 5-6 points on how they differ in their powers. Secondly, civil liberties in India, let's say freedom of speech and expression versus civil liberties in United States of America. Third, the process of election of American president versus the Indian president. Please read a bit about it. Fourth, you may compare the area of Supreme Court of the United States of America versus Supreme Court of India, and what is the difference in their powers. You may in addition prepare how we have an integrated judiciary in India versus the fragmented judicial system that exists in United States of America. Another area could be due process of law versus procedure established by law. How they differ as concepts in India and in United States of America. As far as India and UK are concerned, of course, see, other than that, you should know basic differences between parliamentary system and basic differences in presidential system. Okay, you should know the basic differences in right to equality in India versus right to equality in US. वो सब पहले already UPSC पूछ चुकी है. They have also asked last year question on secularism in India versus secularism in US, which, believe me, there is no difference in terms of what they have asked earlier already in terms of difference between Indian secularism and Western secularism. So you can simply write those same points only. Political theory NCERT के अंदर जो जो आपके points दिए हुए हैं वही सब उठा के लिख दीजिएगा. Now India UK judiciary and judicial powers in India versus judicial powers in UK, that is one topic which they can ask, and how the powers of judiciary are significantly curtailed in UK as compared to India. Secondly, you should compare House of Commons versus the Lok Sabha and House of Lords versus the Rajya Sabha. This is another topic that you can prepare. Possibly prepare something on the CAG's office. What is the difference in India versus UK? That's also something which you can prepare. What else? और क्या हो सकता है इसमें? I'm like just run out of ideas right now. You can talk, speaker possibly, maybe. Speaker could be one. I would say that you can also compare the federal, ये एक चीज थी ना. This is important. Federalism in America versus federalism in India. How they have symmetric federalism, we have asymmetric federalism, how their states are more powerful in legislative domain as compared to in India, where the states are less powerful in legislative domain. We call America as legislative federation. In India, we call it as an executive federation. So those kind of things are also something which you can prepare. Okay. Primarily, these are the things that are coming to the top of my mind. If there is anything else, we have like one more session for how to maximize score and all of that. So maybe we can take up certain things in that. Yes. Actually, एक दो topics और थे जिसमें मैं आपको बताना चाहता था in governance, where I think that what are the kind of questions that UPSC can ask. So let me tell you that and then we'll wrap up this session. वो governance के अंदर, for example, I'll just show you that question and then, I mean, unfortunately we couldn't cover everything, but whatever it is. Yeah, see, in governance, in the topic of civil society organization and NGOs वाला जो topic है, उसमें 2023 में UPSC ने एक interesting question पूछा था. Discuss the contribution of civil society groups for women's effective and meaningful participation and representation in state legislatures in India. इसी की तर्ज पे, इसी के पैटर्न पर UPSC can ask similar kind of questions in some other areas as well. You just need to do one thing. Prepare the basic functions that are performed by NGOs and civil society organizations. What are they? For example, they play a very important role in advocacy. तो किसी भी एक particular topic को parliament तक पहुंचाना है, they play an important role. They do a lot of research to further create awareness and knowledge on that particular issue. So women empowerment, women participation in politics. Third thing what they do is that they are involved in capacity building. So they train people. So the number of NGOs and civil society organizations in India are working on trying to create the capable women leaders for tomorrow. So you can talk about that. They play a very important role in mobilization by gathering people on same issues, by encouraging dissemination of information, deliberation, discussion, so that they can become more aware citizens and they can raise those issues in the parliament, or they can raise those issues in front of the government, etc. So basically, कोई भी standard material आप उठाएंगे, even Vision IS material, you will find that NGOs perform some 6-8 functions. Make a list of that, remember those. Now, whatever question comes, you have to simply use that framework and write answers according to the topic. Now, what are the topics on which they can basically ask with respect to civil society organization in the similar lines? One, they can ask a question on how civil society organizations play a very crucial role in promoting transparency, accountability within the governance. Number of organizations are working in this area. Please prepare a list of 2-3 organizations, NCPRI and the Satark Nagrik Sangathan, etc. All of those 2-3 organizations you can prepare. They play a very important role in environmental justice. So prepare a list of those NGOs which are playing a role in environmental justice or environmental protection. Narmada Bachao Andolan, Chipko Andolan, etc. and all of that. Then third, they play a very important role in disaster management. So basically, see, what I'm trying to say is, no, what UPSC does is, you would, if you have observed the pattern, what they will do is they will simply replace this, discuss the contribution of, of course question को थोड़ा change कर देंगे, but question ultimately will be discuss the contribution of civil society groups for in disaster management and relief. ऐसा कुछ करके दे देंगे वो. Or they will give a question on discuss the contribution of civil society organization in making the election process more free and fair in India. So you have ADR, you have PUCL, you have all those organizations which are working in that particular area. Democratic rights की बात कर देंगे, कुछ ऐसा कुछ लेकर आ जाएंगे. So something like that they will bring up. Or they will bring up how civil society organizations have played a very crucial role in promoting the interest of marginalized communities, including specifically they will talk about SC/STs. तो ये ना आपको you need to learn this thing basically if you have to do well in mains. Previous year question देखा and then try to think, okay, what else from the syllabus can they relate it to? So they can relate it to women, they can relate it to elections, they can relate it to the fundamental rights, they can relate it to environment, they can relate it to disabled, they can relate it to SC/STs. That's how your mind has to work. Okay. So as I said earlier as well at the beginning of the session, the objective was, one, you understand how you analyze previous year questions so that you prepare better for future. And also, by looking at previous year questions, you can analyze what all dimensions UPSC has already asked. So I have to prepare those, and what other dimensions can it ask. So civil society organization dimensions that you will prepare, let's say on the basis of previous year questions, are following. One, you will prepare what are their functions. Second, you will prepare what are their limitations. Third, you will prepare what is the effectiveness or what is the role that they play in furthering democracy and environmental justice and disaster management and this and that and everything. Fourth, you will essentially prepare maybe certain policy or schemes of the government for promoting the NGO civil society organization. हो गया, बस इतना ही करना है. आप अगर प्रीवियस ईयर क्वेश्चंस देखेंगे इन चारों थीम्स के ऊपर और ये जो कुछ चीजें हैं, आप सारे क्वेश्चन सॉल्व कर लेंगे रिलेटेड टू सिविल सोसाइटी ऑर्गेनाइजेशन, रिलेटेड टू दी NGOs that have been asked by UPSC. Similarly, you have to do it for SHGs. Similar thing you have to do for e-governance. Similar thing you have to do for transparency. Look at previous year questions. Understand what are the dimensions that they have asked. Think of possibly other dimensions that they can ask in future, and that's it. That's how you have to prepare for mains. That's how the analysis of the previous year question comes in very handy. Is this clear to everyone? Anyone has any questions? We can give 5 minutes and then we can call off this session. Any questions or any doubts that you have?
UPSC में देखा था, तो उनका जब फॉर्म निकला था तो उन्होंने लिखा था कि जो उत्तराखंड के या निवासी हैं उन्हीं को रिजर्वेशन मिलेगा। तो क्या ये सही है? मतलब कैसे
सही मतलब
रिजर्वेशन क्या डिनाई किया जा सकता है स्टेट हुड के?
If there is a parliamentary law, you can provide reservation on the basis of domicile, otherwise not. Otherwise they can come out with any notification, you can go and challenge it in the court.
सर जैसे डिसेबिलिटी का रिजर्वेशन का डिनाई हो सकता है, ये पूछना चाहते थे हम।
अब सर ये तो बड़ा आप पेचीदा लीगल सवाल पूछ रहे हैं ना, मतलब आप इससे रिलेटेड पूछिए मुझसे, एग्जाम से रिलेटेड पूछिए सर। वो आप एक लीगल क्वेश्चन पूछ रहे हैं जिसका आंसर ढूंढने के लिए मुझे भी वो देखना पड़ेगा क्या इशू आप कह रहे हैं क्या नहीं है। ऐसे हवा में बात नहीं कर
सर
सकते।
क्या रिजर्वेशन डिनाई हो सकता, मतलब ये?
सर मैं वही तो बोल रहा हूँ, ये बात केवल और केवल इशू बेस्ड है, इसको तो देख के पढ़ के बताना पड़ेगा सर। ये ऐसे नहीं, आप इसके रिलेटेड पूछिए, एग्जाम से रिलेटेड।
लिंग्विस्टिक माइनॉरिटी में सर कभी कभी ऐसा हो जाता है कि आप जैसे कि आपको ये भाषा आनी चाहिए, तो
सर आप क्वेश्चन क्या है, इससे रिलेटेड क्या है? वो सब ठीक है आपकी बात, इससे रिलेटेड आपकी कोई पर्सनल समस्या है वो अलग चीज़ है सर। मैं इसकी बात पूछ रहा हूँ, इससे रिलेटेड कोई सवाल है?
नहीं सर, जैसे कि आपने ये सब पढ़ाया था तो उसी से, जैसे कि आपने डिसेबिलिटी का इशू भी है,
हाँ,
तो आपने बोला कि उनके बारे में पढ़ना चाहिए।
नहीं पढ़ना क्या चाहिए,
क्या राइट और लॉ है, आपने ये बोला।
नहीं सर, तो मैंने ये बोला ना, तो आप स्पेसिफिक इशू मत पढ़िए ना। मैं आपको क्या बोल रहा हूँ पढ़ने के लिए, मैं आपको पढ़ने के लिए बोल रहा हूँ कॉन्स्टिट्यूशन में क्या प्रोविजंस हैं। मैं आपको पढ़ने के लिए बोल रहा हूँ कोर्ट की कुछ इंपॉर्टेंट जजमेंट्स क्या हैं टू फर्दर द राइट्स ऑफ द डिसेबल्ड पीपल। वो यूपीएससी में ये थोड़ी ना पूछेगा कि डिसेबल्ड को रिजर्वेशन देना चाहिए कि नहीं, ये सब थोड़ी ना सवाल है। यही तो अभी हमने देखा ना क्वेश्चंस के बेसिस
का तो है प्रोविजन सर, तो
हाँ नहीं तो क्या चाहते हो इसमें, सवाल क्या है?
सर रिजर्वेशन किस किस सब्जेक्ट पे होता है और किस किस सब्जेक्ट पे?
सर ये तो बड़ा अलग टॉपिक है, इसके ऊपर पूछो ना आप, इस पे पूछो मेरे को। इज देयर एनी डाउट ऑन दिस?
चलिए ठीक है सर।
हाँ ठीक है, ओके, यस। एनी अदर क्वेश्चंस एनीवन हैज? यस सर प्लीज। हाँ इनको एक बार माइक दे दीजिए।
Sir, with respect to RPA, what all?
Oh yes, very important. With respect to ROPA, वो actually रह गया because in last 2-3 years they've just asked one question in 2022. With respect to Representation of People Act, please prepare one, what are the grounds for disqualification under ROPA? Secondly, corrupt electoral practices, what are they? And on what grounds can a person be disqualified under ROPA, on what is the procedure for corrupt electoral practice disqualification? Third, you prepare what are the provisions under ROPA as far as the election petition has to be filed and on what grounds can a person can be disqualified, etc. and all of these. These I am telling on basis of already what UPSC has asked. Then, fourth theme which I feel is very important in the upcoming years is why has ROPA not been able to curb criminalization of politics in India? Or has it been ineffective in doing so, and why so? One. Secondly, ROPA and limitations of expenditure during the election. So, why or how ROPA has been ineffective, or it needs to be made more effective to bring down or to keep a limit or ceiling on the expenditure made during the elections in India. So this is another important issue. Third important issue which I think related to ROPA which can be asked, and see these are very broad questions, okay? So इसमें ROPA का कुछ aspect आता है and then they are broad questions. Third topic will be why the hate speech, use of religion and caste-based speeches or religion and caste-based divisiveness have not been controlled effectively by ROPA, and what more needs to be changed within the ROPA in order to overcome these things. So these are three. I think I had noted down a couple of other themes as well. Let me just see. Good that you brought up the ROPA thing. Yes. हाँ, एक मैं लिख ही देता हूँ है ना, because I had written this all down. I mean, there was a lot which I wanted to share with you, but it's just that, I mean, 2.5 hours is not enough to deal with all of this. Paid news. Provisions related to paid news in ROPA and how ROPA helps in curbing paid news and to what extent. तो मतलब मैं just topic लिख रहा हूँ, broad theme. आप इसको अपने आप से इसका analysis कर लीजिएगा further. Secondly, social media and digital media in ROPA, and does ROPA have enough provisions to regulate the functioning of social media during the elections? So prepare that particular aspect as well. Another topic could be, yes, this is very important, inclusion of nota provisions in ROPA, and having a provision where if more than certain number of people vote for nota, then the candidates, those who contested the election, should be disqualified. Of course, I told you about the election limits issue as well. Should there be election limits imposed, and how effective ROPA is in enforcing these, expenditure limits which have been imposed, and whether ROPA is effective in dealing with those particular limits or not. Then what else? Yes, maybe they ask on, yeah, role of ROPA in religion, in curbing religion and caste-based politics in India. Yeah, I think these are some of the themes that you can prepare. Apart from that, you have to prepare basic provisions of ROPA like disqualification provisions, corrupt practices provisions related to electoral funding, provisions related to registration of political parties under ROPA. Registration, 23A, etc. वो सब भी थोड़ा बहुत देख लीजिएगा. I think that should be more than enough. ठीक है? I mean, otherwise तो देखिए आप मतलब सारे sections वगैरह उसको पढ़ना शुरू करेंगे तो then it's not possible. अब वो बिल्कुल कुछ एकदम specific घुस के पूछ ले कहीं पे तो अलग बात है, but when they have done that also in the past, they have done that on the basis of current affairs. If you see question which they asked on election petition, it was covered in the Indian Express Explained. When they asked the question on your ये वाला जो question ROPA के अंदर पूछा था on disqualification under ROPA, it was because Lily Thomas was in news and there were editorials around it which had come. So these are the topics which I feel related to ROPA they can ask in the exam. ठीक है? Any other question? Ma'am, I mean, there is no number, right? How many judgments should be added in the answer depends on the question itself. If, let's say, you are writing about evolution of doctrine of basic structure, unless you write about Golaknath, unless you write about Keshananda Bharati, and possibly even Minerva Mills case, your answer is incomplete. So, I mean, in that case, I would say 3. But see, there is no number as such. It depends on the question. It's like asking same thing, ki how many points should I write in the answer? Even 3 are enough at time, even 5 are not enough at time, it depends. But I think usually you have to understand the nature of the question to see what is required. For example, the question that we saw with respect to environmental jurisprudence, which UPSC has asked, in that you will have to mention at least 2 or 3 judgments. कुछ तो आपको mention करना ही पड़ेगा if you are expecting 6 out of 10. Otherwise, I mean, you write 1, you will get 3. Right? So that's how it works. Okay? Yes, any other question? Okay, thank you so much for attending the session.